All right, I think got everything set up in here. Good afternoon. This is Judge McBurney. I am here on the matter of Andrea Comer as the trustee for a trust versus a Mr. Johnson and a Ms. Brooks. We're going to talk about partition. I think Ms. Jett, you are here on behalf of Ms. Comer. Is that correct?
Yes, Your Honor, and I have Ms. Comer here with me, who is, as you noted, the trustee of the trust, and also on the call is Carl Spielvogel, who holds the beneficial interest of the trust. I don't necessarily expect that I'll have either of them testify, but not knowing if the defendants were going to show up, or if Your Honor had other questions, I just asked them both to show up today.
Okay, well, welcome to both of you. We'll see if we need to get any input from you. And certainly if you have questions when we're done, you should feel free to let me know, see if I can help with that or if that's something for Ms. Jett. Talk to me before we dive into the substance, Ms. Jett, about service. I will note that neither Mr. Johnson, who did file an answer, nor Ms. Brooks is here. Ms. Brooks was served by publication. And I think your theory is that she lives with Mr. Johnson in the house that we're talking about on Hamilton E. Holmes. And they both have a 1/4 interest in the property.
Correct, Your Honor. Yeah, we did. She was, as you noted, Mr. Johnson has filed an answer. As to Ms. Brooks, if you'll look at our June 14th, 2024 affidavit of non-service on here, there are several notes from June 11th and June 12th by the process server where they attempted to serve Ms. Brooks at the property. Mr. Johnson was there on the June 11th date. And then later that day, although he said Mr. Johnson indicated to the process server that he was not in contact with Brianna Brooks, but yet looks like maybe 3 hours later, Ms. Brooks called the process server and she was holding the service documents that he with Mr. Johnson. Hung up the phone whenever he asked, to coordinate getting service into hers. And so for all those reasons, our motion for a service was based on the fact that we believe that she's evading service. We believe she has actual knowledge of this case and what it's about. This all happened back in June of last year after Mr. Johnson filed his answer. I have tried reaching out to him by phone and by also written letter addressed to the property address to try to communicate with him and seek some sort of resolution to this matter. Certainly, Mr. Spielvogel has initiated a number of communications with him before even filing suit, but that's why we're here today, is we just can't get any communication with them to resolve this fractured ownership.
Okay. I'm just looking at his answer again. Okay. And what is the connection, if any, between Ms. Comer and Mr. Johnson?
None, Your Honor. So this property used to be owned by a different Brianna Gibbs, owned the property, and then she got married to Mr. Johnson. And so during the course of that relationship, there was a quitclaim deed from Brianna 1N Gibbs to herself and Mr. Johnson. And then some months later, but also in 2015, there is a divorce decree that Judge Markle oversaw their divorce. And that divorce decree did not address the division of real property. And so Ms. Gibbs gave a deed to Ms. Comer's predecessor in interest. If you give me just a second, I'll get you his name. I think that was in 2020. Yeah, so they were divorced in 2015. And then in 2020, Brianna Gibbs gave a warranty deed for her half interest to Aaron Watkins. And then Mr. Watkins conveyed that 1/2 interest to Miss Comer.
Okay, is this some investment that Ms. Comer made? I mean, I don't get the sense that people are related here in all this.
Oh, yeah, exactly. Yes, that's right. It was an attempt to acquire the property and work something out with Mr. Johnson, and unfortunately, that did not work out. And so here we are.
Okay, got it. Next question I have, and then I'll get out of the way. In the petition, the proposal was sale on the private market. Let's get a realtor, post the sign, do all those magic things, and do an arm's length transaction with whomever chooses to buy the property on the market. In your motion, which admittedly is a year later, so things may have changed, it's now public auction, which is a different vehicle, tends to get a lower price, but also can happen sooner. So I'm curious to understand the evolution from the original request to the current one.
Well, you just hit the nail on the head. I mean, I think that the thought was that once we filed this lawsuit, we could either coordinate a sale with the defendants or otherwise seek some resolution. And be it my naivety or whatever, communications have not gone well. And now I think just given the amount of time that this has been going on, the desire from my client just has kind of evolved to more a whatever it generates, just get it sold. And I foresee, having been through a couple of other of these partition rodeos, if you're doing that, third party private sale, you have to have listing agreements with a real estate agent
and an inspection and all sorts of stuff.
And if they're living at the property and coordinating, even allowing access to to potential buyers to come in and view the property, I'm just anticipating that would be a nightmare of getting them to cooperate, and even acknowledge that there was a court order, obligating them to do all of those things. So even though it may ultimately render less in proceeds, just getting done, my clients paying the insurance, paying the taxes, and they just want to move on.
Okay, and Ms. Comer is paying all the taxes. If the property taxes at this residence were $15,000 last year, Ms. Comer paid $15,000, or she paid $7,500?
No, correct, Your Honor. All of the taxes and insurance are being borne by my client. And so what we have proposed in our proposed order would be, and because not knowing whether or not it would get sold before the 2025 taxes come due, whether the next installment of insurance is just that we would ask that the sheriff deposit the proceeds into the registry, and then we could come back to you with a real time, this is what we're seeking, this is what the offset would be to reimburse Ms. Comer their pro rata share of those amounts.
Got it. Okay. No, that all makes sense. There'll still be some fireworks, I guess, when Mr. Johnson gets notice that the house is going to be sold at public auction. But here we are. Inaction has backed us into this corner. It's not like he doesn't know that there were efforts afoot to try to resolve this. And he can show up and buy it and resolve it that way. Okay. How do you envision notice working? I don't know when one is doing a public auction. Does something have to be run in the daily report, or we don't call it that anymore, the Fulton neighbor, or because we know where Mr. Johnson is, I guess Ms. Brooks is a little more complicated, but if Mr. Johnson is personally served with a copy of the order saying, here's what's going to happen, that's sufficient.
I would anticipate, sending this over to the Fulton County Sheriff. They do, in addition to the tax sales that we all know of, they do all the judgment lien sales, like whether it's HOA lien foreclosures or whatever. So they have their own notice requirement, which I believe is they will post a notice on the property, and then I think they do first class and certified mail to any addresses that I give them. And so I would anticipate giving them the property address for both.
Okay.
So yeah.
All
And
right.
it's obviously 4 weeks notice running the South Fulton neighbor.
Okay. Got it. What else do you want to share with me about the situation?
I think for purposes of just getting this sold, and you anticipated why we've changed the nature of our ask, I think I put in the proposed order a certain time frame. I'm trying to find it. If I don't remember if it was 30 days or what, but I would defer to your honor of like how quickly after the sale you want us to report back any expenses. Yeah, I think I said, within 30 days of filing. Or so no, I said that within 30 days after the conclusion of the sale, the sheriff has to deposit the money, and I have to file with your honor a report outlining the outcome of the sale.
Yep.
And then I just put in there, but I'm open to whatever your honor wants within 30 days of filing that report, that we could just submit evidence to you for how we might want those proceeds to be ordered to be dispersed. So.
Okay. Well, yeah, I'm looking at the order now. So that gives me a good framework with which to work.
And if you want to force a quicker turnaround time for me, I mean, I'll do whatever you want, but.
Okay. Got it. All right. Well, I think I have what I need. I didn't have any other questions. You think that if at dinner time tonight I went and knocked on the door at 244 Hamilton E. Holmes, Mr. Johnson would answer? I mean, as far as you can tell, Ms. Jett, from the work your process server did and the interactions that Ms. Comer or Mr. Spielvogel have had or haven't had successfully, is that Mr. Johnson lives there?
Yes, and in fact, the process server did meet with him at 244. I have no knowledge that he's vacated the premises. I mean, I believe that they're just trying to live there. Well, I can't say rent free. They're partial owners. They aren't entitled to rent, but cost free for as long as they can.
Okay. There was one effort to serve Mr. Johnson at a mango circle.
Yes, the self-drawn deeds that he did in that upper left-hand corner where deeds will often say, after recording, please return to, he put in that mango circle address.
Okay.
And I don't know how or what his connection to that mango circle address was, but we did attempt there because that was an address. Got it.
But then on June 11th of last year, Mr. West was able to hand things to Mr. Johnson at the 244 Hamilton E. Holmes.
That's correct.
Okay. All right. Well, I think I've got what I need. I will have Ms. Niles reach out to you if there are any questions. And I guess if, do we have an email address for Mr. Johnson?
He filed it anonymously, so there's
okay.
I don't even know why that's an option.
Yeah, that's a terrible idea.
It is. So yeah, anytime, so when we filed, I think in our certificate of service, I believe says this, when we filed our motion for partitioning, we didn't just do the standard, served through Odyssey. We physically mailed him an address.
Good.
Copy so we can make sure he knew what was going on.
Yeah, in Odyssey, it shows his address is somewhere in Carrollton. So there's yet another address.
Oh.
Okay. Well, I am all set with what you've given me. I'll massage it a little bit and get it signed, and then you can get rolling on it.
Okay. Well, we appreciate it, Your Honor. Thank you very much.
You're very welcome. Thanks for your patience. We'll get something done.
Okay.
Thank you.
Ms. Comer, any questions, or you feel like you followed what we were discussing?
Yeah, I think I followed it just fine. And I really appreciate your assistance with this.
Well, we'll see. I'll sign a piece of paper. Then Ms. Jett goes into action. The exciting part will come when Mr. Johnson gets word of the order, and I suspect that will result in something else being filed, and we may have to have a few more conversations, but I don't intend to delay things. We'll just have to make time for those conversations in that intervening period between now and whenever the auction date is.
Sounds good.
I appreciate
All right.
it. Thank you.
Thanks, everyone.
Thank you.
Bye-bye. So leave this up for the next thing.
If you want to stream it, everybody should be coming in person.
Yeah. So I'll just mute it in here for now. All right, good afternoon, everyone. I'm Judge McBurney, for those of you who I have not yet met. And we are here this afternoon to talk about a few motions that Mr. Brown has filed. The style of the case is Roderick Brown versus Georgia Power Company. It's 25 CV 001812. And let me get my notes running here. Mr. Brown, you're Mr. Brown.
I am.
Okay, you're representing yourself.
Yes, I am.
All right, we're going to talk about that in just a second.
Okay.
Appreciate you being here. And if I could have entry of appearances for Georgia Power.
Good afternoon, Your Honor. Jeffrey Tompkins and Crystal Holmes for Georgia Power.
Hello, both of you, and condolences to your firm's loss and the city's loss. I appreciate you being here today. I sort of half expected, could we do this a few days down the road? But I think everyone would want business to keep going. So I appreciate you being here. If we need to adjust schedules as we're working through this, let me know. We'll certainly take that in consideration. All right, Mr. Brown, most of this afternoon, we'll talk about your motion for injunctive relief, but you've got a couple of procedural things I want to address.
Yes.
One is, and I addressed it in an order I entered. Are you getting e-filings? If I file something, you get it electronically?
Yes, I am.
Great. You've now asked a couple times for getting some legal assistance. And unfortunately, that's not relief I can provide on the civil side. Certainly, if you were charged with a crime, you'd have a lawyer representing you throughout the process if you could not afford one. But on the civil side, either you figure out how to hire an attorney, you go to legal aid or Atlanta Volunteer Lawyers Foundation, those organizations that might be in a position to offer what we call pro bono support. But otherwise, you're navigating this very effectively, but you're navigating on your own. And I don't have a budget that I can call upon from the county or the state to say, get this man a lawyer.
Could I respond to that, Your Honor?
You sure can.
I guess I would come from a standpoint of that this is a public interest matter. And I wanted to make that, I wanted to argue that to you that given that this, I believe that what you will find out today, that I am going to prove misconduct. I am going to prove that this misconduct may affect over 6 million Georgians. Given that public interest and given that what I will prove here today, I believe that transparency is a matter of public interest. It's a matter of urgency. And I believe you do have the authority. And I understand under criminal cases, I'm entitled to counsel. In a civil matter, when the public interest is great, you do have the authority to appoint counsel or standby assistance, someone to help me, to help the process, to make the process more easier on me, fair for me, and fair for the peoples of Georgia.
Okay. Well, I look forward to you sharing with me the legal authority that supports that idea. I'm not aware of it, but I know about this much, which is very little, about all the law in Georgia. I'm just not familiar with law that would, based on the importance or the significance of a civil case, allow me to appoint someone, maybe not just to represent Roderick Brown, but the people of Georgia or concerned citizens. I will tell you, there are lots of lawyers out there who are eager to help out in that way. And the bigger the case, the greater the interest. So you may want to cast your net a little bit wider, but for today, at a minimum, you're going to be representing yourself. And like I said, I'm always open to learning new things. And so you may identify for me a statute or case law with which I was not familiar that says, here's how a judge can appoint a lawyer. And more importantly, I mean, the reality is, as a judge, I can say, do X, but it doesn't mean it will actually happen. And what I do know with great certainty is that I don't have a bag of money on my desk in there to pay that lawyer. And absent that bag of money, no lawyer is going to say, well, I'm not going to represent Mr. Brown just because you told me to. That's not, that part is not how it works.
Okay.
So let's press on that.
Okay.
Second thing, you had asked for either financial assistance to hire a court reporter or maybe the ability to record what we're doing. I trust you're not recording yet.
No.
Good.
Nothing.
Okay. I don't have an objection if you do want to record things. I'll let you know that this hearing is being live streamed right now. So others could watch it if they aren't able to come to court. But that live stream is actually a recording. So at the end of this session, when I hit shutdown on the computer, then there is a audio visual recordation of what we did today.
Okay.
So you'd have that for posterity's sake. I don't know that a court reporter would say, having been paid by this bag of money we don't have, would say from that, I'm able to make a transcript, but it's certainly better than just my notes or your notes.
Yes.
So that's my fallback. If you also want to record, it looks like you've got a cell phone
Yes.
on a stand. You're welcome to do that. You just need to make sure you turn it off when we're done because the sheriff doesn't allow recording out in the hallways of the courthouse.
Yes.
Okay. Do you want to be heard at all on the whole recording thing?
I think you just addressed it.
Okay.
And so I'm gonna get it done.
All right. Last thing, you contend that there's a discovery issue, and I don't want to dive real deep into that today unless Mr. Tompkins and Ms. Holmes were ready to talk about discovery. I know they're here to talk about your emergency motion for injunctive relief, but I'd like you just to outline at a high level what your discovery concern is, or concerns, plural.
Okay, then. I'm gonna make it short. I believe that it'll be better handled after the hearing, after you hear from on this motion.
Okay.
And then I'll bring it back up. But the points I'm gonna make why discovery has not been forthcoming from Georgia Power is that the mere fact that I am tempting to uncover corruption. I am tempting to uncover unjust enrichments. I'm going to try to prove to you today that there's some evidence of that.
Okay.
And because of that, I believe that my discovery request is more than reasonable. I'm not asking for personal information from nobody. I'm asking for records pertaining to the issues that I'm raising here today. And
Okay.
those alone. And
Well, I like your idea that we'll talk a bit about the motion first so I can get educated, because then it may make more sense when you say, here's why I'm asking for X, and Mr. Tompkins or Ms. Holmes can say, this is why we don't think X is appropriate, or he can have some of this, but here's why we think this other part is either unreasonable or excessive, or we don't have a way of scrubbing it so that Mr. Brown wouldn't be getting personal identifiers for other customers, things like that. Okay?
okay.
All right. So let me give you a thumbnail sketch of what I understand is going on. But before I do that, Mr. Tompkins or Ms. Holmes, were there procedural things you wanted to cover before we get into the motion?
Nothing at this time.
Okay.
We can proceed.
All right. Thank you. So Mr. Brown, as I understand it, your contention is that last year, 2024, your Georgia Power bill went up a fair amount.
Fair enough.
And maybe we'll be talking about why, but either way, the numbers went up. And as a result of that, you elected to participate in what you've called the pay-by-day program.
That's correct.
And your overall contention is that by shifting into pay-by-day, you were misled. Well, you were misled into shifting into it by some representation or representations from Georgia Power. And the net result is that your rates went even higher and you were subject to having your power cut off, you say, without notice. I'll have to understand that better because that's not my understanding of how Georgia Power works. And full disclosure, like you, I'm a customer. I'm not a pay-by-day customer. And my May/June bill was a big number. But it is every year because of this thing called air conditioning.
Yes.
So, but I do want to hear you out on that. And then we'll work through. Today, all we're talking about is whether I would enter that emergency motion that kind of freezes things.
Yeah.
It's not the merits of your case, or anything like that, of whether there was violations of Georgia's RICO Act or Fair Business Practices Act or anything like that. You will be attempting to show me that you have a likelihood of success, that you'll be irreparably harmed if I don't grant this temporary relief, that on balance, the equities favor granting you the temporary relief, and that ultimately it's in the public's interest as well. And you've clearly been thinking about all four of those dimensions.
Yes.
So I'm ready to hear from you. The fact that you are pro se doesn't mean that I'm relaxing any of the rules. So if there's an objection to something you're saying, I'll certainly listen to the objection, and then I'll listen to you as to your response. But I just want to let you know up front, if you ask me, Judge, can you explain to me what that objection is? I really can't. That's not my role. If I'm confused, I'll certainly say, hey, Mr. Tompkins, I don't understand your objection. But if there's legal terminology that's used, I'll do my best to distill it into layperson terminology, not because I'm trying to speak down to you in any way, but just so we're connecting on it. But I am not able to give you advice or, hey, here's how you ought to handle this, or here's an appropriate response to that kind of objection. Okay?
Okay.
Sounds like you're ready.
Sound like I'm ready. Your Honor, I respectfully ask permission to submit the following written statements into the record. I'm asking that due to my inability to, I want to say, read and speak clearly in public. I have everything I'm going to say is it's been written down. But I'm going to point them out to you. I'm going to hand, I made the extra exhibits for them, but it's called Exhibit A. And in Exhibit A, I guess that's why I said I needed help, because I wanted somebody, I was just going to open up and I was hoping somebody was going to read the rest to the court. But if you are going to take it under consideration, I'll tell you what A is attempting to approve.
So a couple thoughts about that. If you're going to tender something like Exhibit A, you'll need to do that. And certainly Mr. Tompkins will need a chance to see it. Does he already have a copy of it?
I brought extra copies now.
Okay, why don't you give, how many exhibits do you have?
Altogether, it's going to be 4 exhibits.
4?
4.
Okay, if you could give copies of all 4 to the other side, because that way Mr. Tompkins or Ms. Holmes can be looking through those while we're moving along.
And do you want to take one as well? Because I'm just going to read the top.
So I won't take them yet,
Okay.
because if you try to admit it and it's not allowed in, I really don't need to look at it. Maybe / shouldn't look at it.
Okay, then.
Although I'm happy to, I may need to referee the dispute if there is a dispute.
Okay.
And before we go further, I will say, you're not required to read the whole thing in. If you can get it admitted, let's just take Exhibit A as an example. If there's not an objection for it to come in, and that's sort of what you want to share about some of the issues,
Yes.
I'm happy reading that at my own pace back in chambers after we're done for the day. Again, assuming there's not an objection from Georgia Power's lawyers. And that way you don't have to read it if you're more comfortable saying, this is my submission. It's almost like arguing this on the briefs, because another way we could have handled this would have been you file a brief in support of your motion and say, I don't really need to argue anything more, Judge. It's all on the paper. And then Mr. Tompkins and Ms. Holmes would have a chance to file something in response if they wanted to. And then basically the parties say, Judge, you go read it and you can decide based on what we've submitted. And that may be sort of what you're trying to do,
Yes.
and that's okay.
So I guess these are the other D. B. Here go B and C as well. And D and E.
Did you, Mr. Brown, get all 4 exhibits A through D to the defense?
Yes, I have.
Okay, great. Mr. Tompkins, I don't expect you to have digested all of them entirely. Do you have a general sense of what the 4 are, or TBD?
A little bit of both.
Okay.
As I can tell at this point, having given these cursory review of these 2 of them, I haven't looked at the other 2. It seems to be Mr. Brown's argument based on credible public sources. He's getting information from the internet and various other places that he wants to present to the court.
Okay.
Obviously, that's hearsay, but.
Okay. Got it. So, Mr. Brown, the lawyers for Georgia Power will continue to read through what you shared. A is what? Sort of a written version of the argument you'd be making.
Yes.
What's B?
B is more factual, as he said, public record
Okay.
documentation of.
What's an example of something in B that Georgia Power has 200,000 customers or?
And net profits, stuff like that.
Okay.
Net profits last year, disconnections,
Okay.
stuff like that.
I bet they made a lot of money and they disconnected some people's power.
190,000.
Okay. What's C?
C is going to be if you want to jump to C.
I'm just curious. I'd just like you to summarize. So A is your argument, B is facts. What's C?
C is proof of corruption.
Okay. Is that the red folder?
That's the red folder.
Okay. And what's D?
D is, since I gave them my exhibit numbers, D is basically me just asking you to consider the case as a whole and underlining what they shouldn't have done compared to what they did in C.
Okay.
It's explaining why they shouldn't have done it. And
So D is argument from you?
yes, argument from me.
Got it. Okay.
Supporting C.
Okay. And C, what's an example of something in C? I don't want you to get into the substance of it, but is it, hey, I found an article online, or I interviewed someone, or?
My actual bill.
Your bill?
Yes.
Okay, so C is one bill? It's a thick folder.
Yes, it's a thick folder. I had a bunch of stuff in it, but C is my bill,
Your bill.
and it shows that.
So I don't get into the substance. You just tell me it's your bill. Is it one bill?
Yeah, one bill.
What's the period of the bill?
The period of the bill is the exhibit spans from January the 27th through March the 29th. I'm gonna draw your attention
Of what year?
of 2025.
Okay.
I want to draw your attention to specifically February the 5th.
Okay. Well, if and when we get there, that's what you'll draw my attention to. But what you've given to Georgia Power's lawyers is that bill. That's Exhibit C.
Yes.
Okay. Got it. Okay. So if A through D are admitted, is there more that you want to say, or that pretty much contains what you want to say?
It contains what I want to say.
All right.
If A, B, and C are admitted, and it contains, I want to give you the gravity, and A and B, I'm trying to give you the gravity because you keep saying me, there's a public interest here. And
Okay.
I'm trying to explain that public interest. What is that public interest in A and B? I'm telling you what that public interest is.
Okay. And I'll want to hear from you on that. I need to maybe remind is the wrong word, because I may not have engaged with you on this yet, but the lawsuit is Roderick Brown versus Georgia Power. It's not Roderick Brown and all similarly situated individuals, or Roderick Brown and the good people of Georgia. It's not a class action lawsuit
Okay.
yet.
Yeah.
If that's something you're going to turn it into, the procedural steps you need to take, et cetera. And so one thing I may hear from Mr. Tompkins or Ms. Holmes is that some of these things aren't relevant to this case, because this case is monodimensional only in this sense. It's your account and your situation. That is not me saying it doesn't exist anywhere else. I'm hearing you suggest that you think that what you went through could be true for many other customers, but they aren't suing. You're the one who's suing. And so I won't artificially focus just on you, but there'll be reasons to say what happened to Fred Jones or Sally Smith. That's a different case. And Fred Jones isn't here right now to say, I'm upset too, or I didn't know, or there's actually an explanation for my bill. My bill went up because I got an electric vehicle and they made my bill go up. I used to not plug my car into my house. I used to go to a gas station instead. We don't have Fred to explain that. We have Roderick Brown.
Okay.
All right? Okay. Mr. Tompkins, I'm not putting you on the spot if what you received is voluminous. I'm curious if you and Ms. Holmes have a perspective on, do we proceed sort of based on the pleadings, give you a chance on behalf of your client to, I don't want to speak out of turn here. So you filed I need to turn the docket around. No, you filed a response in opposition to the motion for injunctive relief. So that's out there. You filed it with your answer. You haven't had a chance to digest what's in A through D. So I've got a couple of ideas. One would be give your firm some time to look at that and say, look, let's just make that part of the record and we're going to file a response to that. I'm also fine proceeding orally today to see where we get. It may be a little smoother given Mr. Brown's representation that the sum and substance of what he would try to get into the record or before me today is what's in the four corners, if you will, of the four exhibits. Copies of which I don't have yet. And so you all would have a chance to look at those and say, you know what, let's just make all of them part of the record, or A and C, but not B and D. And we're going to file a response, or we have exhibit 2 from the defense that you want me to consider. Do you have thoughts on what's the smoothest way to move forward?
I'm happy proceeding either way.
Okay.
Quite frankly, I've looked at, just thoroughly, but I've looked at the documents that Mr. Brown has presented to us. And I think when Your Honor has the opportunity to review, understand what they are and what they're not. Go ahead.
If you think making those 4 exhibits part of the record would sort of complete the record, and then the points you've made, I haven't had a chance to review. I skimmed it when it was first filed. Your response to the motion for injunctive relief, if the points and principles made in that, in your mind, continue to be persuasive, then we may have everything we need. We needed to have the hearing, which we're doing. The hearing would consist of whatever additional conversation we have, plus A through D, and then I'll have the motion, your response, and A through D. And if you're comfortable that those are all the pieces I need, then I don't want to burden Georgia Power with a additional response in light of what happened today.
Sure, and I'm comfortable that these 4 documents that Ms. Brown has submitted, if we make them a part of the record, you'll have everything you need.
Okay.
I mean, probably pretty obvious what I'm going to argue.
Okay.
And it's sort of set forth in the response that the response was there and filed with the answer, which is very short because it didn't need to be long, quite honestly.
Okay. I appreciate that. So, Mr. Brown, I'm going to admit A through D. If you do have copies for me, you can get them to Deputy Gordon, and those will be made part of the record.
Can I confer with counsel, make sure I give it to you all in the correct order?
Sure.
Because
This is your A, as I understand. I actually have 5, but that's your A.
yes. So do that. It'll be
Fact sheet.
Fact sheet. Oh,
See your bill.
yeah.
Yes, that's what I had to see. And then D says, here is the case in law.
Yes, here's the case in front.
Then there's the fifth, I'm not seeing. Is this something I should have in my head?
I guess that's for me. So it's gonna be 4. It's be clear on
That's D, is that?
that big, let's see. That.
Thank you, sir. So I'm gonna label mine. There's one that says oral presentation. It's 1 page. Is that A?
That's gonna be considered,
Pardon me?
it should be 2 pages.
2 pages?
Yes,
There's something called fact sheet for hearing.
okay, that's the fact sheet for hearing.
I have that as D.
Okay, you have it.
Fact sheet for hearing is Exhibit B,
Yes,
and that's just 1 page?
it should be 2 pages. It should be 1 page with a little bit.
Yeah, it says, Your Honor, I respectfully ask this. Is that page 2 of Exhibit B?
Yes, page 2 of the.
All right, I'm gonna staple that. So I got Exhibit B. I have a Georgia Power bill that's stapled. That would be Exhibit C. Aha, I think I have page 2 of the oral presentation. It starts with profit metrics. Those are the first 2 words at the top.
That is correct.
Okay, of the second page?
Yes.
Yep.
Yes,
All right, that's Exhibit A. And then Exhibit D has in bold, here in the case at bar at the
Yes.
top. I've got everything. All right. So, Mr. Brown, I believe the proposal is that I look at these and look at your original motion, Georgia Power's response to that, and then get an order in place that rules on your motion and Georgia Power's response. Does that work for you?
that would work for me, but may I explain C to you?
Sure, it's in evidence now, so why don't you talk to me about C?
Okay.
This is your bill
Yes.
that looks like it's a little different. You had said it was the 27th of January through the 29th
Yes,
of March. It lists here start date of January 1, end date of April 4th. But I'm sure we're all looking at the same thing.
okay.
Okay.
I might have cut off there.
Okay,
What
tell
I-
me what you want me to draw from Exhibit C.
I want you to look at, do you see 2/5/2025?
The date? Yes. Okay, I do.
And do you see how it's expanded? It's open a little bit.
Yes.
See a $500, we can call it payment
Okay,
that was received from the federal. It's, as you will see in my arguments in those exhibits, the federal government give money to low-income families to help with their power bills. That money is given for a specific reason and cannot be used for nothing more than that specific reason.
so, and are you a recipient of that money?
I was a recipient of that money.
Okay, and what's it called?
It's called the Low Energy Assistance Program.
Okay, so you get that money, does it go to you first or does it go directly to the,
Directly from the federal government to Georgia Power.
okay,
And it's
once a year, once a month,
only 2 times a year.
2 times a year?
Times a year.
So this $500 was a semi-annual transfer from the federal government to Georgia Power to help defray your energy expenses?
And I'm explain a little better. Generally, when you behind in your bill, in your light bill, get behind, if you're low income, if you qualify, you can go to entities and ask for assistance. One of those are the federal program for the low income assistance program.
Okay.
You go to them, you bring your bill, you show your rearage. This happened twice. I don't have documentation for October, but this happened in October and this happened in February. I got a $5 allowance in October. That $500, at the time I owe like $580. That $500 should have been to reduce that $580 to $85. It did not. That's why my bill grew so much from November. At the time I fell behind because I had medical problems and I was hospitalized for several surgeries. So I fell behind for a couple of months. That's how this whole thing started. After I recovered, I went and seek financial assistance, got it, was awarded a $5 check. Georgia Power took it, so they applied it to the bill, reduced the amount, and I paid the additional amount over time. Okay. If you use the program the right way.
These numbers on Exhibit C, they show what you were paying.
It showed $500 that was allotted to me, to Georgia Power.
Yeah.
And this shows how Georgia Power used that money.
Okay.
Georgia Power in this exhibit used $125 to reduce the bill. They took the other $375 and put it on my account for future payments. This is really important, y'all, and this is the heart of this case. First, Georgia Power cannot move them. Regardless to what council may say, the law says they can't move that money for nothing. That money is to go to arrearage and nothing else. It's clear.
So where would the money go?
Okay, Georgia Power.
It doesn't go to you.
It doesn't go to me.
Does it go back to the federal government?
No, it goes on my account so I can pay my future bills. So like.
But I thought that's what you said it did.
See, if they would have applied the $500 the right way the first time, I would have just owed $85. Over time, I would have paid off the $85. I would have got off the day-by-day program, and we wouldn't even be here today. Because the money was misapplied, what happens is until you clear your bill, you stay on a pay-by-day program. You can't come off of it.
Why is the pay-by-day program a bad thing?
Because you don't know what your fee may be. Your fee can go from anywhere from, as you will read in my argument, your fee can be anywhere from $6 to $15.
Okay.
So one day I can pay $6. Tomorrow, just because Georgia Power just told me, guess what, Brown? Mr. Brown, today your power bill is $15 for whatever reasons.
Okay.
They're going to justify it, but I'm stuck at that. Another harmful effect, whilst I'm on this program, I'm kind of like pushed out of the going to get help because of requirements of how you can apply for help. So long as I'm on this program, I'm stuck here. I'm on this day-by-day paying scheme. And let's just stay on point about why the money with me. This $325, it went on my account to pay for my future, whatever they say my bill be, to borrow the next day.
I thought that's what you wanted it to do.
No, that's not what I want to do. Your Honor, nobody want to be on the day-by-day program. Anybody get on the program, you know that your bill is going to, I was only paying $190 for lights prior to this. I'm paying $500-$600. I'm on a fixed income, Your Honor.
So I'm looking at, it's kind of hard. This bill that you printed out just shows what you paid as opposed to what you were billed.
Your Honor, what the law says, you can't touch that money. You can't determine how that money is to be deployed. That money is to go to the rich and nothing else. That's federal law.
Well, except you told me that if
go ahead,
the amount you get is more than the arrearage, then it should be a credit on your account. Just these simple numbers.
I misspoke then.
Okay.
This is how I go, Your Honor. I owe, when they had this money.
Let's just keep it simple. You owe $5. You get $10 in the low income assistance program.
They won't give you that. You can never get over. You're only going to get, they're going to look at your bill and they determine.
They're going to give you less than what you owe.
You're never going to get over. You're never going to get over. It's always going to give you, they're going to pay.
So when they sent you $500.
My bill at the time was $800. $800.
Okay. Then I guess.
Matter of fact, it was $1,000 to be accurate, Your Honor. It was $1,000.
What's a deferred balance?
The deferred balance is Georgia Power thing that they created in this day-by-day program. But Your Honor, you need to understand the importance of this. First of all, the money can't be moved. Let's get past that. But by moving it, I'm stuck on the program. I'm paying at an extraordinary crazy rate, and I'm locked in. it's instead of reducing the balance, it's beneficial to Georgia Power doing it the way they do it. Because they misusing funds. They using to where they can, now, Mr. Brown, you got to pay whatever we tell you to pay. If you was off the program, you would only pay your $194 a month. Because you own the program, your bill is down $200, $300, $400 a month.
Why don't you get off the program?
Because I'm on a fixed income. Y'all, those 190,000 people that you don't want to hear about, we all got in jams.
So I'm going to interrupt you there. Don't say that again. I don't not want to hear about all these people. You are not the spokesperson for those people. Legally, you're not. You have filed suit on behalf of you. So I don't take kindly to you suggesting that I'm not sympathetic to other people in a bad situation. I would, of course, want to try to help them out if legally that was appropriate. But you don't speak for them. And frankly, you don't know what's going on with their accounts. Right?
I don't, yeah.
Okay, so let's focus on Mr. Brown.
I guess I was trying to just show, when I had spoke of it in the past, I was just trying to show you a pattern, Your Honor. And we can just reasonably assume that if this is going on and this is how you misusing the money, then you probably misuse the money in other
It's probably not happening in just one place.
Exactly.
Got it.
That's all I'm trying to say. Your Honor.
Okay. The question that prompted you saying I don't care about people was, why don't you just step away from the day-to-day program?
Because if I step away, my lights go off immediately.
Has that happened? Or you think that's what would happen?
That's going to happen, Your Honor.
Has it happened?
Your Honor, the program is set up like this.
No, just please, yes or no question. Have you said, I'm getting out of the day-to-day program, and actually your lights went off?
It have not happened, Your Honor.
Okay.
But
do you have any documentation from Georgia Power that says if you withdraw from the day-to-day program, we will turn your lights off?
Every day they send us a message. When you own the program, you get a text message and you get a call first thing in the morning. You have $4 on your account. Add more money or your lights will be cut off. That's what the recording is saying.
Okay.
Every day.
It actually literally says your lights will be cut off?
Your lights can subject to be turned off.
Okay.
You must add more money on your account. And so you got to get out here and you got to do whatever you got to do. And you better put money on the account because when it runs, as long as it stays to the plus, you're good.
Yep.
When it drops down to that, you get cut off. And when I'm not on the program, if I fall behind my bill, I may have a month or two to try to work it out. Go get from a church organization, go here, go there to get the money. This day by day, we don't have that option on this day by day program.
But I'm confused. How long have you been on the day by day program?
Ever since, I think.
How about this? Last October, when you got another $500, were you on day by day back then? Don't look to Mr. Tompkins. I mean, you would know whether you were on day by day.
No, I think it was. I think he's going to say November. I think I was on like in November, or.
So you've been on day by day for about 6, 7 months.
6, 7 months I've been on
Okay.
because I can't get off.
I don't know that you can't get off. I only one more question, and then I'm gonna let you talk more about what you want to talk about. But I think it's all on the paper here. In February of this year, it sounds like you were carrying a balance because the 500 didn't. You don't get money from the low income energy assistance program unless you're carrying a balance.
Yes, that's right.
Okay.
That's why I'm saying I can't go down. You got to come to them with a bill, and that bill must state in red, your power is subject to disconnection.
Yeah.
That's the rule.
Okay.
You got to have that bill, and they got to be a rearage with that. And that's what from that whatever your amount that you owe, they determine how much money they're going to give you.
On February 5th of this year, you had a negative balance.
Yes, I did.
They didn't cut your power off.
I didn't have they didn't cut my power off because they was giving me, I had time to work on it. I was still not outside of their range. They got like a 2-month window in which you can work on getting your bill paid off.
So it's really not the next day they turned it off. They give you a 2-month window.
I was already on the program then and already had a ridge in February on it. And all the money was to pay that ridge down.
Okay.
That money was given to me, but the balance was running because I was on and they didn't cut it off. Georgia Power just moved it to the rearage because I was on the program, and the money was given to them to reduce that rearage.
Okay. Got it. And that's the deferred balance? Arrearage is deferred balance?
Yes.
Okay.
No.
No?
That's just for this deferred balance on Exhibit U. That's just the money that Georgia Power used of that. It was a lot. It was a award of $500. Georgia Power used $125 to put on my rearage.
Right. No, I understand. Yeah, because the other piece of paper you have attached to it doesn't really have a date.
That's what
It says your deferred balance is $888.
Exactly, yeah.
Okay. All right. I better understand that. Thank you for explaining.
Okay.
Was there more you wanted to share?
No, not on the bill itself. No.
Okay. Anything else?
One other thing that I got handed back. I'm gonna give me a minute to get it together. But what it was my list of one of the things I must prove to you here today for you to make this award of what harm I'm suffering. And I had that in E.
E, you didn't tell me about E. You just went through D.
We stopped there because E is not an exhibit. It's my argument to you
Okay.
why I should get the relief I'm asking for.
Okay, well, why don't you make that argument and then I'll see what Mr. Tompkins or Ms. Holmes has to say in response.
Okay then. In Your Honor, the actions of Georgia Power has caused me the following actual ongoing harm. One, I listed as living in constant fear of disconnection. And I explain it. Is there any objections to me making this part of the record? Because I got to list out what that harm was.
This is E?
This is E.
Okay.
Mhm.
All right.
That was one of the reasons. The
Constant fear of disconnection.
Two was loss of ability for future energy assistance. What I was arguing there is because I'm on this day-by-day program, I only have 1 day to make. When, according to Georgia Power announcement to me, right now I'm on a day-to-day program. And when that money reaches zero, they cut my lights off. That's what has been told to me through their recording and through their text messages. So I don't have to get on one of these programs takes anywhere from 2 weeks to a month. And sometimes it takes 2 months because they are sending a notice to Georgia Power. This is how they do it. They send a notice to Georgia Power, don't touch his lights. We got this amount covered for you. And Georgia Power, because this has been going on over 30, 40 years, this energy assistance program through United Way and the federal agency been going on over 40 years now. Georgia Power will understand what they're supposed to be doing with this money. So I lost that ability to seek further assistance by being on this program. 3, emotional distress. I guess you can see that in my trying to make this argument to you right now. That's just emotional stress because I'm living in fear. I don't know when my light's gonna go off. I don't have a bill. Y'all gotta understand. I live off this suit is rented. I got the receipt right here in the pocket. I gotta take it back to the store when I get finished this meeting.
We rented a nice suit. You look very nice.
But it's rented, and I got to go back to the store because I can't afford it.
Don't get ink on it.
So you live in constantly with that fear. And my income is $980 a month. That's disability. That's what I live off.
And that pays rent as well, or you do not have to pay rent?
My kids, they volunteer to help out.
Good.
But this month, whilst everybody else was eating barbecue, lobsters, and steak, I ate cold cuts.
I didn't have any lobster, but I'm feeling you.
I ate those cold cuts because I also have a medical insurance policy. And that medical insurance policy, because of my age, disability, and whatever not, I get an allotment, food allotment. That food allotment is $190. I had to convert that $190 to make a payment to Georgia Power, and the records are going to show I made that payment to Georgia Power. I took it off my medical card and paid to Georgia Power rather than to buy food. So I did not have barbecue this holiday.
How are you paying for the cell phone?
The cell phone, that's part of my daughter. It's on her plan. That's part of a family. That's a family plan. It's 9 phones on that plan. That's all the kids and me. Everybody contributes to that. So it's, I'm here fighting. I'm here fighting a big company.
Okay.
And I just wish.
So emotional distress is number 3.
Emotional stuff is number 3. Financial hardship, again. Number 4 is financial hardship. Again, I'm robbing Peter to pay Paul. Right now, I'm taking money from my food allowance, from credit cards to keep the lights on. Because like the lights, you know, in this heat, it's just a must. Just got to get it done.
Do you live alone or do you have roommates?
And it's me.
Just you?
Just me.
And you mentioned that your kids are supportive. Do they live locally or are they far away?
I have one daughter in Sacramento, California.
That's far away.
That's far away. She's in the Army Corps. She's a sergeant major. So she's in the United States Air Force. I got a daughter in Milwaukee, and I got 2 kids here in Georgia.
You're all over the place.
Yeah, so yeah,
Okay.
because I came to Georgia, they want to come this way too. Eventually, everybody gonna be, I guess, at one point. But everybody contribute. If I need $50 here, I need $100 here, I need $200. They're just gonna do what they can, and I'm just gonna float between. Like I said, prior to me getting sick, this was not an issue. I work, do whatever I gotta do. My disability and make side money, I was doing good. But when I went in the hospital for that 2 months, it killed me. It got me behind. I ain't been able to catch up.
Do you not get, in addition to disability, monthly Social Security payments, or that's
Yes.
all rolled into one?
It's all rolled into one, Your Honor.
So that 900 figure, whatever you get, that's everything.
That's all the money I'm getting. That's my disability and my Social Security retirement.
Okay.
Because I lost disability. When you get to your Social Security retirement, they cut your disability off.
Okay.
So yeah, I got one lump sum.
Okay.
And so that's why I was making that argument. And I guess that's basically was it. That's basically it. And I submitted to you. And so I believe those hardships and what I think, if you really would look at, see what can and can't be done with the money that's awarded, you will find out that can't be done. You can't do it that way.
Okay.
Can't move that money around.
Well, those are very real concerns that you have, and
Real.
whatever flows out of today's hearing as well as this lawsuit doesn't in any way suggest that they aren't serious concerns. You're very much living hand to mouth given the small payments you get, and life is expensive, and you've identified some significant costs. So I'm sorry that this is not what you should be stressed about at your age. You've lived a good long life, raised some good kids, and ideally you would be enjoying that barbecue as opposed to cold cuts. So I'm sorry you're feeling the way you're feeling. I'm of course constrained by what the actual legal options are, and I'm going to hear from Mr. Tompkins or Ms. Holmes in just a moment. I won't rule from the bench. I need to read all the things that you've shared and reprocess the brief from Georgia Power. And of course, my ruling is just on your emergency motion. We still have the rest of the litigation that we need to get through, okay?
Okay.
But I appreciate you, number 1, being here, and 2, sharing what you've shared. It's not easy to talk about what you're talking about, so thank you. Mr. Tompkins or Ms. Holmes? You're looking at each other. He's like, come on, man, you stand up.
Yeah, I'll brief it. I simply asked it, Mr. Brown, when this lawsuit was filed, I called her and offered to go to his house, to sit down with him, to go through his invoices, to explain to him exactly what they meant. Now, I've had several conversations with Mr. Brown, upwards of probably an hour, maybe, I don't know, an hour and a half, maybe, most recently. And I've tried to explain that, one, Georgia Power has no incentive to try to cheat him or anyone else. Georgia Power is regulated by the Public Service Commission. It doesn't make up its rates. Its rates have to be approved. I learned, both through some of our research and from Mr. Brown, this is not his first time being on the pay-by-day program. He's been on it before. That program is a safety net, if you will, to assist people just like Mr. Brown. It's there to help them keep their lights on. Mr. Brown talked to you about the assistance he's received. Some of the assistance he's received over time was not by virtue of his seeking out that assistance, but by Georgia Power doing it. By Georgia Power trying to help him keep his lights on.
How does that work? Georgia Power communicates with a customer saying, it looks like you're struggling here. We can connect you with the low income program, or Georgia Power actually applies and says, you're going to notice on this bill, there's make the number up, $80 credit. We've obtained an alternate source of payment for you.
It's the latter. That's what has happened at times to assist Mr. Brown. I think the Salvation Army donated money, or money was obtained by Georgia Power from the Salvation Army for Mr. Brown's benefit. Ms. Brown mentioned, if your account gets to a certain point, you're in danger of having your electricity disconnected. Unfortunately, that's true for everyone. We all have to pay for the electricity. Mr. Brown has the option, as I understand it, of applying whatever amount he can or desires to his account. He knows how much electricity he is using on a daily basis. He has the ability to go online to see that. And he's charged for that actual usage. Now, I'll be quite brief because it's in the brief. He doesn't meet any of the requirements for an injunction. He called it an emergency injunction. Now, I understand he's a layperson. It's an interlocutory, but the point here is he can, if he prevails, he can get money damages. If we cheated him out of some money, and we haven't, but if we've somehow cheated him out of some money, he can get it back. There is no irreparable harm here. And again, I won't make all the points. You'll read them, and so I don't need to bore you with that. I'm satisfied with the arguments that we make in the brief. And I'll simply say this: the injunction he is requesting is an extraordinary remedy. The code section clearly disfavors injunctions, right? Only in certain clear cases. This is not one of those cases. And while Your Honor has the discretion to do as you please, I think the facts suggest, no, the facts dictate, I believe, that Mr. Brown is not entitled to an injunction. Mr. Brown is here about Mr. Brown. If you read some of his pleadings, at one point he says, there were 190,000 people who had disconnections. Millions were served by Georgia Power, but 190 had disconnections. But then at another point, he says, this is about getting back, Mr. Brown, getting back to the $194 he was paying at a certain point. And I'll leave you with this. Georgia Power didn't put Mr. Brown on the pay-by-day program. Mr. Brown chose to go on to the pay-by-day program.
So it's not mandated when someone continuously is in arrearage. It's, look, we're going to disconnect you, or you're going on pay-by-day.
Here's an option for you.
Okay.
He chose that option, and as I said earlier, it wasn't the first. He's chosen that option. Several years ago, Mr. Brown, and I don't remember the date he told me, I don't know that he actually remembered it, but Mr. Brown was on the pay-by-day program.
And got off it with the lights not going off.
Exactly.
Okay.
Exactly. It accomplished its goal. Mr. Brown, if you read the complaint, he thinks that Georgia Power is being unjustly enriched, is pocketing the money. No, the money is going to assist him and only him. So I'll sit down and be quiet.
All right. Thank you, Mr. Tompkins. I do have one question. If you look at Exhibit C, we spent a fair amount of time on that. Mr. Brown expanded, and it may have done naturally. I'm not saying he did anything in particular, but that February 5th entry where there's that total payment of $500 and it shows $125, but as a negative going to a deferred balance and $375 to account balance. How do you interpret or translate that entry?
Yeah, the honest answer is I don't exactly know, Mr. Brown.
Me neither.
I wrote down what he said. Georgia Power well understands what they're supposed to do with this money. He's right. They're not gonna violate any laws in how they apply the money. I do know this. When Mr. Brown went to the pay-by-day program, his arrears didn't go away. And so he's required, and it's on the bills, to pay this arrearage. And so a portion goes, he was on a flat deal before that. So a portion goes to cover that, as well as the additional electricity that he is using. But the details of how, I honestly do not know.
Okay, the part that confused me is it sounded as if, you can't tell from this bill, so I'm not attributing anything to anyone, that on February 5th of 2025, Mr. Brown had an arrearage of more than $500. If he didn't, then to his good point, the government wouldn't have sent across $500. They're always going to send less than the arrearage. And so the way I understood his observation was why, observation/question/suspicion, why is Georgia Power only attributing 125 of that 500 instead of all 500 to the arrearage, and then this 375 goes somewhere else? And I don't think it's in Georgia Power's pockets, but it just it's a peculiar entry. It seems like all 500 would be deferred balance amounts, but it could be that in Georgia Power E's, meaning their language, deferred balance and account balance, and he had negatives in both. And so they were actually, look, you need to pay off both, and don't know why, we're putting 125 in this direction and 375. And so they consumed it all to reduce his overall obligations to Georgia Power, but maybe it didn't go into the bucket that seemed most logical. And so we're having some of this discussion.
Sure, and I concur with that, actually. I know it all goes to benefit him. And, he's showing you the bill, but he's not showing you the entire balance and his usage and those sorts of things. But I've got some of his bills and they were attached to the answer. He thinks that his bills are going up, but they're actually applying this money.
Okay.
And it's applied over time, but.
Well, it'll be helpful to look at the attachments to the answer. I think that's great. Okay. All right. Mr. Brown, we are almost out of time, but you are the movant, so I do want to give you final word.
You want me to stand up, sir?
I'd like you to be comfortable. So if you're comfortable sitting down, I was able to see and hear you before. So however you want to do it.
Thank you for this hearing, first and foremost.
You're welcome. You're entitled to it.
Okay. I would like to make a couple of points as well. Mr. Thompson said that Georgia Power helped me. Georgia Power don't help us. Georgia Power don't solicit money for us. We go to United Way. We apply for that money after waiting days and days and lines and on phones. And we tell them that we owe Georgia Power some money. So that was an incorrect statement he made right off the rip.
Okay.
So that's totally incorrect. They have never called me, Mr. Brown, we're going to do something for you. It have never happened. Again, about this program being somewhat voluntary. As you explained it, when you ask them, how you duck the question, you ask them, well, wait a minute, when you call Mr. Brown, do you say, okay, here your bill is due, what you gonna do? And he kind of vaguely got around, well, I had an option. I don't have no option. When I was on the phone with that representative and I'm behind, just got the husband behind, they saying, you got two choices, Mr. Brown. And they got recorded in a phone call. They know with it. She said this, you got two questions, Mr. Brown. You're going to either pay this bill in full or you're going to go to this day-by-day program or your lights go out. There is no give and take. This is how they doing me as a customer. So I'm speaking about me right now.
Good.
So maybe they doing different than somebody else, and then that would be another form of description.
That would be a different problem. You're right.
But what I was told, this is not optionable. You can pay it, go on the program, lights off, end the story. Again, 3 years ago, the reason why I brought you all these new figures about disconnections and money made by them is relevant to right here. As Mr. Thompson said, I was on this program several years ago. And at that point, they applied the money the right way. And because they applied the money the right way, that rears got paid, I got off and went on about my business, and I ain't crying and didn't file no lawsuit.
Okay.
The problem this time is, as he alluded, kind of get around, they've misappropriated funds on 2 occasions. They can't do it. It can't be done. That's a violation of law. That's just the way it is. So that's why we're here. And I'm asking you for relief because I am being harmed because of their criminal conduct. Because if I'm right that it's against the law to move that money and not apply that money properly, then guess what? You have harmed me through their actions. And I'm entitled to relief because I'm suffering. I may not be a $1 billion company. I may not have meet all these things, but as an individual, I meet that threshold. Their actions are harming me. Their actions may be, let's say highly unusual. He could not answer that question about where the rest of their money went. It didn't go in their pocket. It went, the reason why they had so much profit last year, because there was a guy like me probably, with this guy right here, that got taken advantage of, where that money went on a shelf at this high rate. Unjust enrichment is obtaining money unlawfully. They obtained the money. Yeah, they still got $500, but the way they did it, they are making more money off the money we got. By holding me in this program, I am paying more every month. I'm not going without barbecue and all this stuff. I am being harmed. So I totally believe that whoever wrote the law wrote it for a guy like me. This is what we mean when you put an injunction. Hey, let's stop the harm. Let's figure out what's going on. It does not hurt Georgia Power to pick my bill back the way it is. What harm comes to Georgia Power? He don't dispute that they made $2 billion in profits. So what harm does it come to pit me back in a place where I can somewhat survive? This is not harming Georgia Power. You right now, granting this motion sends a message to Georgia Power, a message that needs to be sent, that if you guys are doing something wrong, you guys are going to pay down the road. And for right now, I need to protect Mr. Brown and protect Mr. Brown because Mr. Brown can't afford this. He can't afford you guys taking advantage of him. You claim you got $2 billion profit, Mr. Brown eating cold cuts. That's not fair. And I'll rest on that, John.
Thank you, Mr. Brown. I appreciate you again being here and sharing all that. Mr. Tompkins and Ms. Holmes, I appreciate you being here in this complicated time for you and your firm. But you're pressing on with business, and I appreciate that. I will take under advisement Exhibits A through D, as well as Exhibit E, which was Mr. Brown's very effective closing argument there. I'll look at what's in the docket, and I will get something out. Mr. Brown, I'm rolling into my next hearing now. You've seen a couple lawyers walk in.
Okay.
But you had mentioned discovery. We should defer that till now to talk about discovery. You said there was a discovery dispute. Can you give me a thumbnail sketch of what the concern is?
The concern is they not giving me documents I'm requesting.
Okay.
And maybe I need to give you a list of what I request so you can have a better understanding. And that way.
What's an example of something you've requested that you're not getting?
They are only giving me my bills and nothing else.
Okay.
And
why should you be able to see, for example, my bills?
Well, I should be able to see disconnections on a whole. I should be able to get those numbers. I shouldn't see your bill with your name on it, but you can easily wipe your name out. But this case is about, Your Honor, even though it's just one plaintiff right now, which that's on me to make it bigger, but it's about unjust enrichment. It's a RICO. That's a conspiracy. It's got to be more than one. For me to prove that, I got to show a pattern of wrongdoing.
Okay.
That's what the case is about, showing a pattern of wrongdoing. And in my complaint, I do say similar suited individuals, even though they're not here right now.
Right. Mr. Brown, what did you do before you retired?
I was Atlantic Steel worker. I was down here at Atlantic Steel Company. Always been in management my entire life. So I'm in management. Steel company. So
back when it was a steel mill and not a giant shopping mall, you were working there?
Yeah, I was working as a crane operator.
Fantastic.
Yes, that's where I retired from.
You are a part of history.
Yes, I am.
Okay. Well, Mr. Brown, I appreciate your passion for this, and I appreciate Mr. Tompkins and Ms. Holmes's representation of Georgia Power, and I will be in touch. What I'll do, I'll work through the emergency motion, and then it may be that I get us on a Zoom call so people don't have to come all the way into court. to talk a little bit more about Discover. You've helped me understand the sort of nature of your concern. I certainly need to hear from the other side. I suspect I know their concern about the relevance and the sensitivity of other customer records, but you've explained, I don't necessarily need to know that it was Fred Jones and Sally Smith. It was of the 190,000 people who were disconnected, I'm making this up, how many were on the pay-by-day program? And if the answer is 11, that's a lot less of a conspiracy than you think it is. And if the answer is 190,000, then there may be something else that you want to explore. So we'll see if that's something that we get to. Okay? Thanks, everyone. Please pass it to the rest of the firm.
But he would have it no other way.
I figured as much. I mentioned to a colleague, like, oh, I have a case with them on Monday. Like, I don't know if they're going to be there. I said, I bet they will be there because you carry the torch. You may not with a smile on your face every day, but you carry the torch. So. Thanks, Mr. Brown. Go return the suit. Don't spill on it.
Okay, yeah,
All right.
it's got to go back.
Okay.
I can't afford it.
Nice to meet you.
Appreciate it. Okay.
Yeah, I could see him as well at first. I knew it was him. The lid was just.
How does Georgia Power, most of the Georgia Power cases I've had have been with Balch. I think this is one of the first with your firm. How do they look at it and say, but the ones with Balch have been like a truck ran someone over or something like that. And this is more of a businessy dispute. How do they decide?
Yeah, there's no real rhyme or reason. I spent a fair amount of time at Balch.
Okay.
Cases together.
All right.
In fact, the last argument on an injunction, I argued on Zoom from Balch.
Okay.
They do the line and share for the Southern Company, both entities. And we got involved maybe 10 years ago.
Okay.
That's a guess. And most of what we get, most of the cases are tort cases of all sorts.
Okay.
Yeah.
Well, they're a good client to have. They, sadly for them, keep having torts. With that many trucks and power lines and this and that.
Well, and what's interesting, I didn't know this. They put more miles on the road than any other entity in the state of Georgia.
Really? So
50 million miles a year. And if you think about it, you know, going here and there, all of the.
it's just the odds. I mean, they could be perfect drivers. There's still going to be a deer runs in front of the truck swerves, hits a pedestrian, and there's a lawsuit. And they see Georgia Power. They see $2 billion in profit. Like, let's sue these people.
That's exactly right. Yeah. I've had them where there's a storm, the tree falls, knocks down the line, and they run into the tree, and it's Georgia.
That's wonderful.
So, but yeah, but there's no rhyme or reason. We get a little bit of things. Good to see you.
Carry on.
Thanks.
See you guys. Should I keep the Zoom?
No, we'll start at 3:00.
You have your own Zoom?
Yes.
Okay.
Did anybody
Except
follow
you'll
IT?
have to invite, what, I'm sorry,
IT?
what about
Is it? IT? What's there?
I don't know what. We have to light the cameras,
Sure.
but I don't know